everyone, and welcome to today's webinar. Before we get started, I wanted to share some housekeeping rules. If you have any questions, please use the toolbar at the bottom of your screen to enter any questions. And after both the presentations, we will open the floor for questions. Today, we have two speakers today to talk about the Department of Homeland Security's rule limiting duration of status for foreign students to 4 years. To provide an overview of the rule along with its legal and practical implications, I'll introduce to you Bob White, and to discuss advocacy efforts and opportunities related to the rule, as well as broader policies affecting international students and researchers, I introduce to you Heather Stewart. So without further ado, I will pass it off to Bob.
Okay, thanks, Rachel. Hi, everyone. I'm Bob White. I am a principal in the immigration group of Masudu Funai, based in our Schaumburg, Illinois office. And as some background about me, so I've been practicing in the employment-based immigration area for more than 30 years, with a real focus on assisting schools and their students' employers navigate the immigration system. I am a member of the American Immigration Lawyers Association Student Visa Task Force. I was one of the members who drafted AILA's response to the proposed regulation, which then turned into this final regulation. And also, I'm active in NAFSA, which Heather is part of NAFSA. And I was what's called a regulatory ombudsman. I was chair of one of their regions. So I've just been actively involved in this whole area for many, many years. I'm going to give an overview of where we're going, basically, where we've been, and also where we're going with this final rule, which was released about a month ago on July 17th. There's three main pillars or components to the final regulation. There's the elimination of duration of status. So currently, F and J non-immigrants are admitted to the United States for the duration of status, basically the duration of their programs, their studies, plus any employment authorization at the end of that. That pillar is going to change. And we'll talk about that in a second. Then the Department of Homeland Security is also going to be introducing really, really severe, and I call it draconian, restrictions on academic flexibility. And then the third pillar is there's a transition rule. It's not a grandfathering rule, it's a transition rule for the students and exchange visitors who are present in the United States prior to September 15th. So September 15th is basically D-Day when this rule goes into effect, assuming that there's no litigation which delays that implementation date. And I'll briefly talk about that, and I have a feeling Heather's also going to talk about that too. So how long have we had DS? More than 40 years, actually since 1979. And there was a period of 2 years from 1981 to 1983 where they tried to change DS to this fixed admission date, which is what they're going to be doing now. But that only lasted 2 years because the legacy INS was just overwhelmed with with extension of stay applications. So they went back to the DS system. So we're all hopeful that this will also only last a short period of time, if at all. And the period will only be 2 years or less. But we have to talk about what is being implemented now. So why this change now? After 40 years, why this change? So in the preamble to the final rule, DHS, the Department of Homeland Security, provided a couple different justifications, and I'll just briefly give them to you. First, they said it's necessary to increase oversight, deter fraud, and address national security risks. The second is they said that the increased volume in F and J non-immigrants has posed a monitoring challenge for DHS, even though they have spent millions and millions and millions of dollars in the SEVIS system, which is basically the oversight of F and J non-immigrants. Another reason they said DS does not afford DHS enough predetermined opportunities to verify that F and J non-immigrants are only engaging in authorized activities. And then lastly, they also said that they do not believe that eliminating DS will be an undue burden on anybody, which is, in my opinion, completely false. It's going to be a significant burden on students, schools, and employers. So the regulation was released on July 17th. It's 153 pages, but it's well worth the read if you have not already done so. Spend a couple of hours because even though the main pillars of the regulation, the final regulation, did not change from the proposed regulation, there's just a lot of detailed information in the preamble explaining how DHS is going to be implementing certain parts of the regulation. Now, I gave my first webinar on this issue the day before the final regulation was released. The preview was released on July 16th, and that was 556 pages. I had 4 hours to read. I didn't get through all 556 pages, but about 400 of them before that webinar. There's been chatter that people believe that not everything from the preview is in the final regulation. That's not true. Just if you're going to read the final regulation. So some notable quotes from the preamble. The first is that designated student officials, DSOs on the F side, and responsible officers or officials on the J side should no longer serve as direct proxies for immigration officers. Another notable quote, DHS recognizes that foreign students play a role in stabilizing enrollment and support the financial health of many institutions, including community colleges. However, DHS has concluded that the benefits of this rule outweigh any potential decrease in enrollment or financial impact to those institutions. Third notable quote, DHS will hold accountable aliens. That's their word, not my word. I would use non-immigrants who violate their F1 status as well as their educational institutions. Another notable quote, DHS expects F and J non-immigrants to consider the cost that they're going to have to incur based on the new requirements that we're going to be discussing in a second as a cost of attending school. So you're going to have tuition, room and board, DHS costs. So they want that just to be considered to be factored in as part of attending an institution. And then lastly, so DHS is committed to providing clear guidance and training to all stakeholders. We haven't seen a lot of that yet. So far, we've only seen one set of FAQs that was released by the Student Exchange Visitor Program, SEVP, on July 17th. And then also this past Monday, the Department of State released some guidance for the J programs. But so far, the guidance has been limited. We are hopeful that there will be more FAQs. SEVP has indicated that they will be giving a seminar in about 2 weeks, or a webinar in about 2 weeks. So hopefully it will answer some of the questions that really are still open, that have not been thoroughly addressed in the preamble to the final regulation. We've been compiling a list of questions. We have at least 40 that we've been pulling from various blogs. So there definitely is things that have not been answered yet, which hopefully DHS will provide more guidance on that. So will this go into effect on September 15th? More likely than not. So I think Heather's going to be talking about the Congressional Review Act as part of advocacy, and then also potential litigation, which her organization, NAFSA, may be involved in, and there may be some other suits filed too. So, but if a court does not step in and issue a restraining order or some type of injunction, this rule will go into effect as of September 15th. Also, in the regulation, there are a lot of severability provisions, which means that if a court strikes down one part of the regulation, the remainder of the regulation can go into effect. So a court would have to really strike down the whole regulation, so which may be a challenge too. So even though we do have hope, again, institutions, students, their employers should be prepared for this regulation to go into effect on September 15th. Okay, so let me start talking in a little more detail about the pillars that I talked about. So that first one was the elimination of DS. So again, this begins on September 15th. So any F or J non-immigrant who enters the U.S. after September 15th is going to be subject to the new regulation. There were various groups that were advocating for exemptions from this requirement. In particular, physician groups were advocating to be carved out of this requirement. But DHS decided that every F and J is going to be subject to this elimination of DS. So if they're eliminating DS, what are they replacing it with? So there's new terminology now. It's called an AUD. So what is an AUD? An AUD is admit until date. So for most other non-immigrant classifications, when they enter the U.S., when they're issued an I-94 record, they are issued a specific date which they are admitted to. So now F and J's will also be admitted to a specific date. So what is the date? So the date is the end date on their program, as indicated on their I-20 form for Fs, or on their DS 2019s for Js, or 4 years, whichever is less. And also, this applies to dependents. So you have to keep dependents in mind too. So you have this AUD date, which is program end date, 4 years, whichever is less. And then they're giving a departure period of 30 days, a grace period, departure period of 30 days. Currently for Fs, they have a 60-day grace period. That is being reduced to 30 days. So the big question is, how is an institution and an employer going to be tracking all these AUD dates? Well, in the preamble, DHS indicates that they are going to be updating the SEVIS system with AUD dates, and also that either the DSOs or ROs are going to be able to pull reports about the AUD dates. The preamble says that we are hopeful that this is actually the case in about a month when this regulation may go into effect. We would still encourage institutions, employers to review I-94 records when people travel internationally, just in case the SEVA system is not accurate. You have to get that date corrected, because what happens if somebody misses an AUD date? So we're going to talk in a second about extensions of AUD dates, but if a student or exchange visitor stays beyond their AUD date and they are not authorized to continue staying beyond the AUD date, then an unlawful presence clock will start ticking. And if the student or exchange visitor remains for more than 180 days, they could be barred from re-entering the U.S. for 3 years. If they remain beyond their AUD date, not in an authorized status, for more than a year, they could be barred from re-entering the U.S. for 10 years. So I mentioned dependents before. Dependents are often forgotten in many of these processes. You cannot forget dependents. They will also have AUD dates, F2s and J2s. Hopefully, SEVIS also provides that information for tracking, not just the principal, but also the dependents. But again, the dependents cannot be forgotten about. So the existing students who are present in the U.S. before September 15th, again, though they will be eligible for transition rules, which we will talk about in a second. The AUD date is coming up. What does the student or exchange visitor have to do? They really should be doing this as early as possible. So they either have to apply for an extension of stay on an I-539 application through U.S. Citizenship and Immigration Services, USCIS, or travel internationally and re-enter with a new I-94 record that extends their AUD date. To re-enter the U.S., you need a valid visa, unless you're Canadian and visa exempt. So you have to keep that in mind. There's a lot of uncertainty out there right now. There's travel bans. The travel option may be a little bit riskier than the extension of stay option through USCIS. But everybody is going to have to decide on their own which of those two options that they would like to proceed with. So what has to be evidenced for an extension of stay? So the preamble states that the evidence should include that the student or exchange visitor has the funds needed to live and study in the U.S. without engaging in unauthorized employment, that they are maintaining a residence abroad to which they intend to return. They have pursued or are pursuing a full course of studies or maintaining the terms of their program, and that they're completing their studies within 4 years or are able to provide a permissible, and I'm going to put permissible in quotes, explanation for taking longer. So, what is a permissible explanation? So, first is if the I-20 form or the DS-2019 form indicates that the program takes longer than 4 years. Okay, that should be a permissible explanation. But if that's not an option, then currently DSOs in the F program are able to extend programs if the student is making a normal progress. DHS in this regulation is eliminating normal progress and they're replacing it with three options. So the first option is the student would have to evidence compelling academic reasons as to why it is taking more than 4 years. And they define this as isolated or temporary academic difficulties, not repeated or prolonged inability or unwillingness to complete studies. The second option is documented illness or medical conditions. And lastly, it is sort of a catch-all, but not really a catch-all, circumstances beyond the student's control. And those circumstances are defined very, very narrowly. Natural disaster, emergencies, a school merging with another school with a program being eliminated. So very, very narrow exception under that catch-all of circumstances beyond the student's control. The one nice thing for Jays, and this was contained in the preamble, I thought it was really interesting. And then State came out with their guidance on Monday, which this was not contained in the proposed regulation, but it is contained in the final regulation. So for Jays, if a J program is a DS 2019 is issued, let's say in 1 year increments for a residency program, for example. The resident is uh, issued the I-20 or the DS 2019 form every year throughout their residency program. But the residency program takes 5 years, let's say. So on the DS 2019, the RO in field 3 indicates the current length of the program, but then they're allowing the RO to indicate in field 4 the total length of the program, and if the exchange visitor is traveling internationally, the exchange visitor should be readmitted not for that period in field 3, but the length of the program not to exceed 4 years, which is contained in field 4. So the guidance that was released on Monday really laid out all the different exchange visitor options and maximum periods that could be indicated in that field 4. State provided really detailed and very good, in my opinion, guidance. So if you haven't reviewed that and you do have J non-immigrants, you may want to review their detailed guidance. So risk and costs. Risks, again, I said traveling internationally, the risk is you won't be readmitted. Or if you have to apply for a visa, you're not going to be issued the visa. If the risk with applying for an extension of stay through USCIS is the officer in his or her discretion does not agree to extend the AUD date. So those are the risks. And the cost, if you're traveling internationally, you have that cost. If you're applying for the extension through USCIS, you have the filing fee, possibly attorney's fees as part of the cost. So when to apply for an extension of status if you're applying through USCIS? You should apply as early as possible. So talk to the DSO, the RO, to see if they can extend the program, or if you do need the extension, that they can recommend the extension as early as possible. In the preamble, DHS said that it's recommended to apply for the extension at least 6 months ahead of time, but there is no restriction on how early somebody can apply. And just to give you some just insight, currently for F1 reinstatement extensions, USCIS is currently taking 13 to 15 months. So we're hoping that extension timeframes do come down, but that's where they currently are. So if a student fails to apply for an extension by the AUD date, the student may have to apply for reinstatement and to file for an extension of stay. So just some final words about extension of stays. In the preamble, DHS indicates that eligible students should have no difficulty getting an extension of stay application approved. So they also said this in the proposed regulation. Our comment said, well, if there's going to be no difficulty, then why do we have to go through this? But again, this is the way that it's being rolled out in the final regulation. But even though they say no difficulty, they also state elsewhere in the preamble that they are estimating that at least 25% of the students will need assistance from an attorney when filing an extension of stay application. So that is just an overview of that first pillar. Now, the second pillar, which I said before is draconian. I've had one DSO say to me that she believes it's bonkers. So let's just go through the restrictions. The regulation breaks students into groups, basically. So there is the below graduate level group, there is the graduate level group, and then there are students in English language training programs. And this is all for F non-immigrants. This does not impact Js. So for an F1 student on the below graduate level, in their first academic year, they are not going to be able to change majors or change schools. Unless they get an exception from SEVP, not USCIS, SEVP. And in the preamble, and also in those FAQs that SEVP released on July 17th, they indicate that the exception is for rare, exceptional events beyond the control of the school and students. So some examples they provide: withdrawal of SEVIS access, again, a school merger that eliminates a school's program, a natural disaster or emergency. So those were their examples, but it's not limited only to those, but again, they do reemphasize, that the bar is very high to be approved for a rare and exceptional exception. So what is the process going to be for SEVP to review these? We don't know yet. We were kind of hoping that this would be contained in at least their first set of FAQs, but it was not. So hopefully they provide additional guidance on that. Also, the other thing to keep in mind is if the student does, after their first academic year, change schools, change programs, it may necessitate the filing of an extension of stay application or traveling internationally if that extends beyond the AUD date. So that's the below graduate level. What about on the graduate level? It's even more harsh. So on the graduate level, the rule does not allow for any changes in educational objectives, levels, majors, ever, ever. So there's no exception to that. And in the preamble, in response to one of the comments about an institution's ability to help their graduate level student if he or she is failing in his or her major, their response was basically, well, if they fail out, they just have to depart the U.S. So just very, very severe. One slight change from the proposed reg to the final reg involves transfers on the graduate level. So a student on the graduate level is able to transfer schools, but again, the bar is very high. It has to be due to those rare exceptional events that I just previously talked about. And SEVP has to approve the transfer request before it can occur. So again, very high bar, but at least they did give just a modicum of flexibility there. Changing educational levels. So, as with the current rule, the new rule does allow students to progress into a higher level of education, but the final rule, unlike the current rule, does not allow for lateral matriculation. So, for example, going from one master's program to a second master's program. It also does not allow for reverse matriculation, which is going, for example, from a master's program down to a bachelor's program. So there's no exceptions to that, those limitations. So that has opened a whole host of questions, especially about blended programs, pathway programs, dual degree programs, multiple degree level programs. In the preamble, DHS sort of addresses those, but not fully. The one thing they did say, though, is that they recognize that there are bona fide educational tracks, graduate program specializations, and market-driven licensure requirements. And the need for a little flexibility in those areas. So they did state in the preamble that they will be providing guidance to clarify. That was not contained in that first set of FAQs released by SEVP. But again, we're hoping that they provide much more detailed information about various permutations that may occur within a same level of programming. So basically, stay tuned for that. Also, there is no change in educational objectives or transfers. if the student has been placed on academic probation or school suspension that's contained in the regulation. Also, severe restrictions, limitations on English language training programs. They are going to be instituting a lifetime cap on ELT programs of 24 months. And in the preamble, they addressed comments about, well, let's say the student goes home during a break for 3 months, or the student incurs some sort of medical emergency, medical condition, which does not allow them to continue studying for a period of time. Can they recapture that time? And the answer was no. So 24 months capped, no exceptions, no extenuating circumstances. DHS did clarify, though, that everything in this pillar, all these academic restrictions, are prospective in nature. So if a student has completed 3 master's programs in the past, is now on the bachelor's level, will be completing a bachelor's degree after September 15th, they would be allowed to progress to the next highest level of education and start another master's degree program, even though they have already completed, the 3 master's programs before September 15th. Also, DHS gives themselves a little wiggle room here. Uh, they've indicated that they could delay the implementation of this pillar, all these academic restrictions, for up to 2 years. And the assumption is if there is any delay, it's going to be due to technology issues with the SEVIS system. But as of now, they have not indicated that there is going to be any delay starting on September 15th. If there is going to be a delay, it would be announced in the Federal Register. Employment. How does this impact employment authorization? For F1 students, optional practical training, OPT, J students, academic training, AT. So the regulation does not change those programs. And also, I should throw in for F1's curricular practical training, CPT. So the regulation does not change the fundamentals of CPT, OPT, or AT, but there are timing issues. So if a student is able to timely file an extension of stay application and they're an F1 student, and they file before their program end date, not during that 30-day grace period, they may be able to extend their on-campus employment, severe economic hardship, CPT, and for J's, AT, as long as they file for that extension before the end of their program end date, not during the grace period. And that extension, again, is up to 240 days. So that's why it really is imperative to apply for the extensions as early as possible. And timing is going to become an issue with optional practical training. Optional practical training can be approved up to currently 14 months after a student completes his or her course of studies. Again, I said before that they're taking 13 to 15 months for extensions with reinstatement applications right now. So you have to get the extension first. And then apply for OPT. The student may want to apply as early as possible. One thing that DHS did confirm is that both the extension of stay application and the EAD application can be filed concurrently. But again, we don't know if they're going to be adjudicated concurrently. So at least until we know that, and the assumption probably is no, that extensions should be filed as early as possible. We've gotten a lot of questions about, isn't premium processing available? Premium processing will not be available, or is currently not available either, for extension applications. It is available for EAD, OPT applications, but not the extension of stay applications. Also, cap gap relief, they confirmed, is not being affected. That's H-1B cap gap relief. So students who have employers file quota registrations on their behalf, which are accepted, and then the quota petition is timely filed. Their ability to remain in the U.S. and their employment authorization may be extended up to April 1st, or when the H-1B quota petition becomes effective, whichever is earlier. So lastly, just quickly, so the last pillar are these transition rules. Like I indicated to begin with, this is not grandfathering. These are transition rules. So it applies to students who are present in the U.S. as of September 15th. If the student travels abroad after September 15th, then they suddenly lose their transition eligibility. So students and exchange visitors may not want to travel if they do want to benefit from to the transition rules. So the benefits of the transition rules. So for an F student, if they are going to be applying for optional practical training, OPT, and the OPT application is filed before March 18th, they will not have to file an extension of stay application with the OPT EAD application. DHS also did indicate that they could extend that March 18th deadline in 6-month increments. And they would do that through another publication in the Federal Register. Also, F1 students currently have a 60-day departure period. For transition eligible students, they would continue to have the 60-day departure period. It would not be reduced to 30 days. But again, remember, if they travel internationally and re-enter, they will be admitted for an AUD specific date that will contain the 30 days. So they would lose the benefits of this transition rule. So with that, that was just a lot. But Heather, I'm going to turn it over to you for updates about advocacy, etc.
Thank you so much, Bob. You covered a lot. That's a lot. I'm Heather Stewart, Counsel and Director of Immigration Policy at NAFSA, the Association of International Educators. I have been with NAFSA for a little over 20 years, a couple days. And before working at NAFSA, I worked for a time at the American Immigration Lawyers Association, where I am also a member, and I worked for the changed their name. It was ACIP, the American Council on International Personnel, which was absorbed by SHRM. So I've done business immigration policy and international student policy and some broader immigration issues when I was with AILA. So I'm going to cover two areas. One is the advocacy efforts and opportunities related to this rule. And two, I'll highlight some broader policies affecting international students and researchers. So, advocacy efforts and opportunities related to the rule. As Bob discussed, DHS published this final rule that ends DS and hands unprecedented academic decision-making power over to DHS and specifically USCIS. And as you know, USCIS is ill-equipped to deal with this responsibility. Despite thousands of public comments filed in opposition, they're moving forward with implementation, even though they have historic backlogs right now for adjudications. Um, even though they are going to be doing long-term harm to our economic and foreign policy interests. We know international students and exchange visitors are already rigorously tracked and monitored by ICE, and overburdening USCIS will surely drive away international students and scholars who require more predictable and welcoming destinations. First, Bob did discuss that briefly about potential litigation. NAFSA continues to look at this possibility. There are arguments to be made that they did not follow the Administrative Procedures Act when they published the final rule. It is a major rule and it was defined in the final rule as such, but they only provided a 30-day comment period. Actually, it was 32, but whereas they have the opportunity to provide 60 or even 90 days for a comment period, but they have the abbreviated comment period. And one argument that can be made with the rule is the arbitrary and capricious nature of the rule. And there are many provisions within it that you could make an argument like they did not consider fully the economic impact of this rule on institutions and the United States as a whole, but they are supposed to take the comments that people submit, review them all, and be able to make a reasonable argument as to why recommendations, suggestions like for alternatives that would be less burdensome would not be appropriate. And they uh, out of hand dismissed a lot of the recommendations and did not provide evidence or reasoning for why their version of this rule should move forward as it is. So we hope to know very soon what may be happening with potential litigation, and stay tuned. It should be an interesting ride the next few months, as it has been with this administration. So what can you do? Um, Reach out to your members of Congress. NAFSA, in collaboration with the U.S. for Success Coalition, um, have an online advocacy campaign where you may urge your members of Congress to reject DHS's plan to end duration of status. The web address for this campaign is nafsa.org/don't-end-ds. And the don't does not have the apostrophe. So it's nafsa.org/don't-end-ds. And there are two asks for your members of Congress in this outreach. One is to support legislation that preserves DS policy by adding it to immigration law. DS is vulnerable because it's not included in the INA, the Immigration and Nationality Act. So if we can include it in the law, that makes it much less vulnerable. The other is to urge the congressional review of the final rule through the Congressional Review Act. The first ask, very straightforward, put it into law. The second ask is more complicated. This is to invoke the Congressional Review Act. This process is only available when the rule is classified as a major rule. And interestingly, in the final rule, DHS said it is a major rule. So that hurdle of proving that it should be could be reviewed by Congress has already been met. The Congressional Review Act establishes procedures for Congress to overturn federal agency final rules. This requires action by both chambers, the House and the Senate. While it's a long shot that a Congressional Review Act challenge would be successful, this is a process for Congress to act in their role as providing oversight for the federal agencies. The federal agencies arguably has usurped the power of the Congress in writing the rules in a way that does not comport with the law as written. So Congress, it's their opportunities to step in and say, we disagree with how this is working, and we have a role in bringing this to our members of Congress attention. The more attention given, the more constituents reach out to them and make this something that they need to pay attention to, the better. So turning to broader policies affecting international students and researchers, optional practical training. We know that optional practical training is under threat. The DS rule itself could impact access to OPT, as Bob talked about, needing to file an extension of status as soon as possible to make sure that you have every opportunity for the extension of status to work its way through. Because when you enter, a student may only get the period of time for the program, and the program end date likely will not include OPT. So the requirement for an extension of status will likely apply to everyone, like every PhD student who has to study for more than 4 years, may have to file an extension of status if they want optional practical training. We know that the USCIS director has said that it is his wish to end optional practical training, and there are others in the administration who have set their sights on ending or severely restricting optional practical training. The president has gone back and forth with his support for international students, but we must be clear-eyed that OPT is something that we need to pay attention to. On the positive side, there's a bipartisan bill that has been introduced in the House to protect OPT by adding it to the law. This is Keep Innovators in America Act, HR 8013. Right now, it is only in the House, but it is bipartisan, having been introduced by 2 Democrats and 1 Republican, which that's very good that we have a bipartisan attention to this. There was an interesting side bit of information with how they're getting co-sponsors on this bill. And this is happening quite a bit. From what I understand, what I've been told by both Democrats and Republicans is that they're doing a 2-by-2. I call it the Noah's Ark rule, where to get one new person to co-sponsor a bill, there has to be someone from the other party. So if you have a Democrat, they have to bring a Republican with them. And my understanding is that there's more support for this bill. It's just making sure that it's not too heavy on one party co-sponsors than the other. So if you talk to your members of Congress, they may say, we support the bill, we're just waiting for someone from the other party to join. That's good news. And we all need to work to try to get more people on this bill to build support for inserting OPT into immigration law. Another positive is the bill Keep STEM Talent that has been introduced in both the House and the Senate. And this bill has been introduced in prior Congresses, so you may be somewhat aware of the bill. And in importance to you, the bill creates a direct path to green card for U.S. STEM degree, master's degree, and higher graduates, and exempts them from the annual green card cap, which that's very useful, very helpful. It also changes the how the STEM degrees are defined. It doesn't rely on the DHS STEM degree program list, instead relying on Department of Education list, the classification of instructional programs, and the listing for biomedical sciences and physical sciences, agricultural sciences, a bunch of different degrees. So that may be more expansive than the list that the Department of Homeland Security has. So we know also that it's been a tough year to get visa appointments. in many countries. Excuse me. And NAFSA and others have been advocating and meeting with Department of State officials to try to address this and get increased availability for visa appointments and for swift visa processing. Excuse me. I don't know why my voice does that sometimes. I think we all do that. But so there is a lot going on. But what I would like to say in closing is that don't despair and don't stay silent. Stay informed on DS and what is happening. NAFSA has a DS portal page on our website, and it is nafsa.org/duration-status. We're trying to keep that as updated as possible. NAFSA's Take Action page, we're putting up letters so you can reach out to your members of Congress. Please act where you can act, inform where you can inform. These issues are confusing and difficult to understand. And your outreach to your members of Congress matters. Your outreach to your personal networks, your professional networks really matters. Personalize this, make it understandable for people who don't do this every day or may not be as closely involved as you are. But thank you very much for your interest and using your support to um, supporting international students and scholars. And thank you very much. I turn it back over.
Thank you. Thank you, Heather, and thank you, Bob. So we have quite a bit of questions in the Q&A. So um, I'll start it off with this first question, and that's asking what will happen to current F1 students, specifically students that have already been here for 5 years. Will something happen retroactively where this will convert to 4 years? Could you both speak on that?
Go ahead,
So
Bob.
all of this is prospective in nature. So as of September 15th, what is on the I-20 or the DS 2019 as the end date will become the new AUD date with a maximum of 4 years. So everything that's happened in the past doesn't count. So it's going forward.
And I would just say it will match your program. I think some of the discussion has said, it's 4 years, a maximum of 4 years. So I've heard some people say, oh, well, we'll get 4 years. That's not the case, as Bob said. If you're here for a 2-year program, your end date will be that 2 years. You don't get a full 4 years.
Thank you. There's another question here, specifically asking about J1 visas, and is asking, is it applicable for J1 scholars who are already present in the US that may have been here for 3 years? Is that if that person is transferring to the J1 after September 15th, um, or what is it only for new scholars? So it's similar in question.
There, you want to go first?
Oh, well, as it's the same really as for the Fs. The past doesn't really matter. You'll get the end date will be the end of your program when you transfer.
The one thing that I've been asked a couple times now is if after, so you're in school A on September 15th with, let's say, a program end date of December 1st, then you go to school B and school B's program ends on January 1st. Does the AUD date change? No. So you can't keep transferring schools to extend the AUD date in this transition period.
That's a great question.
Yeah. So, given that there may be a lot of folks that are on these visas that have already been here for, you know, 5 years, maybe 6 years, um, what would um, what would happen to, like, if they're in a PhD program and they've already been here for 6 years, what will happen to them on September? Well, what could potentially happen to them on September 15th?
So it all goes back to their program end date. So let's say they're in a PhD program, they've been here 4 years, and their program goes for another 3 years. Then their AUD date would be, the 3 years. So because it's less than 4 years. But the bigger issue is for students and scholars entering in after September 15th, PhD program. 7 years is the program, so the max they're going to be admitted for is 4 years.
See, because there's a bunch of questions that are very similar to that one. There is a question asking about the AUD. Someone asks, is it true that some people are already receiving an AUD on their I-94 upon entry? And is this possible before September 15th?
So we've heard
Actually,
it now a couple of examples of
yes,
that.
I
And
saw
that's,
one yesterday.
did you? Okay, yeah.
Yeah,
It's not supposed to be happening.
nope.
Sometimes, the port of entry, they're a little aggressive. And I think that really speaks to how there will be a need for education on all sides. The students and scholars will have to understand, and DHS will have to do a massive amount of education. And there are going to be mistakes. And we'll have to try to figure out how to fix those. But there will be mistakes like this.
Yeah. So for my school that had a student admitted for a fixed date, I told them to contact their local CBP office to get the I-94 record corrected because it should be DS. So
Mhm. Uh, Trying to field some questions. A lot of them are very similar. This one is similar, but they do ask, and I think they may be referring to the special considerations or circumstances if this were to be the case. So for fifth, a fifth year PhD student who made a trip out of a country for health reasons, but if they were to return before September 15th, does this 4 year limit or will that apply to them, or will they need to um, get admitted during their um, duration of stay upon entry? I guess they're asking, would they have to go through the process again?
What's that special date? Before that date, you're good in a sense. Like you keep if you're an F, you keep the 60-day grace period, and you can have the period of time to complete your program. So if you're up to 4 years, so that's fine. It's after that date. That's like the demarcation date. So if you return before the 15th, you're good. After the date, you have the new rules that are immediately apply. You still have the transition rules that will apply to you, which has some limitations.
Um, I see a question about um, visas that have already been expired. So, what about students whose visas have expired but admitted with DS and still have a valid I-20? Are they considered to be in a valid status until their I-20 expires, or do they need to complete any additional process to maintain their status?
But just to remember, you only need a valid visa to enter the US. After you enter the US, the I-94 record is controlling. And again, prior to September 15th, it should be for DS. After September 15th is going to be for the length of the program plus 30 days or 4 years plus 30 days, whichever is less.
And that's really confusing for many, the phrase visa. And it's unfortunate that in the press, that visa is used as a placeholder for immigration status. So it does become confusing. It will be challenging moving forward because institutions, schools, individuals will have to keep track of different dates of expiration. You'll have your visa expiration date, so you'll need to know that if you want to travel outside the United States and try to re-enter. You'll need to know the date of the expiration of your program and be able to track that. You'll need to track your spouse, children, and say the primary travels in and out of the country. The primary might get a different AUD date than the dependents because of that travel. So you've got to make sure that you're keeping track of the various dates and understand what the various dates mean vis-a-vis your status and your ability to travel.
I'm going to throw in one more date too, Heather. The passport expiration date. Uh, our One of our really big concerns is if the AUD is shortened because of a passport expiration coming up, then things are not going to sync. You have the program end date, all the other dates that Heather's talking about, and you get a reduced AUD date, which the student or exchange visitor may not be fully aware of.
Trying to field some more questions. So here's a question. And I think the, there are a lot of reoccurring questions because of this specific question here. Stating that most graduate programs do not have a specific duration date. So after the initial period of classes and exams, how is it determined what the length of the program is? Is it by the average time to degree? Um, and I think that's why we're getting a lot of reoccurring questions. Is like how are they tracking or how are they setting that standard for that?
Uh, so when the school is every 2 years they have to recertify with SEVP, and they indicate program lengths. So the length of the program should not exceed what's on the I-17, but it should be the realistic period for the program. Heather, do you have other comments about that?
And isn't it also what appears on the I-20 or the DS 2019 for the expiration of the program, the program end date? They will refer to that. So it it further separates the concept of your education from the bureaucracy of it all. Like the program you might be taking is pretty open-ended. Like it could be 2 years, it could be 4 years. It depends on your interest, and you can, add classes or not. But the school itself has identified this program lasts 2 years or 3 years, and that's what they tell SEVP when they get certified to admit international students in that program. And then when the school fills out your I-20 or DS 2019, there's a date that's put on that as the date the program ends, and that would be what would be considered. Whereas your school, maybe in talking to the individual, may say, it's a little fluid, but there is that expiration date.
So we've had some schools say, well, can't we just put down any date? No, it does have to be consistent, internally within the institution, but also you have what has been indicated on the I-17 form. So if the I-17 form says that the program is 3 years, then on the I-20, you can't suddenly put down it's 5 years.
Hmm, thank you. So we have another question about in terms of applying for the extension of stay. So how early is it recommended to apply? And can OPT and extension of stay be applied for together at the same time, or should it be applied one after the other?
So this
I
is
think it's
really confusing, but Heather, you want to start and then
I was just going to say for filing for OPT, the extension of status and the work authorization EAD at the same time, concurrent. And I think Bob, you mentioned during your piece that We don't know if they'll be adjudicated at the same time or if they'll be adjudicated at a separate time. And for when to file, it's as soon as possible. But Bob, I think you understand the regulations a bit better than I do on what the time frame allowed for that is.
So, with the extension of stay application, they confirmed that there's no restriction on how early you can file. But for the OPT, the I-765 application, there is a time restriction, and that's 90 days before the completion of the course of studies. So, the student may have to file the extension of stay a lot earlier and not try to do it concurrently until we know if USCIS is going to be adjudicating these actually simultaneously based on the OPT filing dates, not the current extension of stay filing dates. Because as I said before, extension of stay filing dates for reinstatements, 13 to 15 months. For OPT, right now it's about 5 months, give or take.
So still more to find out. I
Yeah.
mean, right? I mean, we still
Yes.
need more information. And one, we hope that DHS will continue to share information about how they will be interpreting these and implementing these. But I think we will be finding out more as, as the months pass.
Yeah. And
All right.
I think, oh, thank you. I think there's a lot of questions about where to find resources or more information or guidance on a lot of these for specifically for like extension of stay and AUD. Where should our members go if they're looking for more guidance?
DHS for the F program has a whole site called Study in the States. So uh, it's Study in the States, all one word, .dhs.gov. And in the search bar, just type in final rule, and they have a whole page on this issue, this topic.
Thank you.
That's great. And NASA will be keeping our information up to date. And I will put a link in the chat box here in the yeah with the address just so.
Yeah, and if you are a NAFSA member, fantastic resources. The one I would suggest you look at is they have a red line of the current regulation and the future regulation, and you could see how much is changing.
Thank you. Um, have a question here regarding dependents. So, how will the change concerning an extension affect a spouse's EAD?
Uh, so they must be talking about J2s because F2s are not eligible for employment authorization. So for J2s, it's unfortunate that they're not making accommodations for the J2s by allowing for an automatic extension of their employment authorization while the extension of stay application is pending. So the J2 spouse is going to have to apply for an extension as early as possible in order to try to prevent some sort of a lapse between the current EAD card and the future employment authorization. So timing for J2 spouses with employment authorization is really going to be critical.
So, because we have so many questions, I'll just kind of open the floor to see if you both have any um like any special considerations that you think that everyone should do. I know you both said to apply as early as possible for the extensions. I guess is there any words that you would like to leave everybody with?
I think for me, it's try not to panic. Um, Understand the dates, like what dates you have. Like sometimes for me, well, I will have a list. This is when this expires. This is when that expires. So you for yourself can understand if you're the student, if you're the exchange visitor. Um, and for those who are providing advice and guidance to them, I think try to maintain your level of knowledge, rely on the experts, Ayla, Mr. White here, um, how NAFSA can be helpful. Please let us be helpful. Um, and remember to communicate your concerns up the chain, across the chain, down the chain, because this is not widely understood by many, and just the impact this will have on people's educational opportunities, on research opportunities, and the rolling impact this will have, um, and the totality of the situation, because there are so many different regulations and policies now that are very, very restrictive in whether or not people continue to study and work and do research in the United States. Um, Becomes a question with the totality of the circumstances. So, yeah, thank you for your continued attention to all of this, and I appreciate all the work that you'll have to do to for this to work well for all of you, or as well as it can.
And just adding to what Heather said, we are all in this together. So students, schools, employers, everybody's going to have to track everything, AUD dates, etc. Plan early for extensions, and like Heather was saying, just communicate. If something goes awry, it's not going to be a limited just to your students or your workers case. It could apply to multiple people. So if you share the information, then we can possibly as a community try to troubleshoot. So and as Heather was saying before, there's going to be a lot of one-offs because the government needs just so much training on this. You look at all the training that we're giving, they are going to need even more to implement this properly. And there's just going to be a lot of mistakes, unfortunately. And hopefully it's limited, so they learn, we learn. So this is rolled out, in the long term, to try to minimize the impact. And as Heather was saying, it's an impact to everyone. And I'm going to throw in the economy too, because there definitely is economic implications here. And DHS realized that by calling this a major rule. So, as Heather was saying before, so we're all in this together. So let's all continue to communicate through our various channels.
Thank you both, and thank you both for taking the time to speak to our members on this really important rule that's unfortunately going to change a lot for those in our community, not necessarily in a positive way. And really, this is a very helpful resource for everyone. So thank you both very much. Um, and that concludes our webinar for today. This recording will be posted on the ASBNB website, and stay tuned for more updates pertaining to rule on our advocacy center. Thank you all.